It's day 2 of jury deliberations, and it wrapped in the murder trial of Kyle Rittenhouse, who faces 5 felony charges after shooting and killing 2 men and injuring a third at a Black Lives Matter protest in Kenosha, Wisconsin last year. As deliberations continue, tensions grow in Kenosha with 500 National Guard troops on standby in anticipation of a verdict. BNC's Walter Morris joins us live from Kenosha tonight.
Well, good evening. A much calmer scene out here outside of the courthouse. Jury deliberations wrapping up on the second day with no verdict, and the jurors will be back at it again tomorrow morning. Now, they spent about 8 hours today deliberating. They started out early with a few procedural questions, and that sparked a debate between the defense and the prosecution about where they would view video evidence, either in the jury room or in the courtroom on a big screen, and how many times they could replay it. But that was just the beginning. Eventually, a couple hours later, the defense actually asking for a mistrial for the second time this week. Now, this time over the quality of video evidence. Now, it's kind of like when you send a video over text or email. It may look fine to you, but the person who receives it gets a grainy copy, a much pixelated copy. Now, the defense is saying that is what happened with drone video overhead that showed moments of the shooting. Now, they're saying the jury saw a much clearer version in court, and they may have even changed positions had they gotten that evidence. So now, of course, the jury will be back tomorrow. A couple tense moments out here. Police actually arresting 2 people, and the jury deliberations will begin at around 9 a.m. local time, 10 a.m. Eastern. Reporting live in Kenosha, Wisconsin, I'm Walter Morris for Making the Case.
Walter, thank you so very much. So from outside to inside the courtroom, the jury deliberated for 7.5 hours. They sent several questions to the judge asking to see videos, including drone footage, which shows the encounter between Rittenhouse and Joseph Rosenbaum, the first man he shot. CK Hoffler is back with me. All right, CK, before we get to the jury notes, let's talk about this judge who can't stay out of the headlines. He found it necessary to address what he calls misinformation in the media regarding his delay in ruling on the defense's motion for a mistrial with prejudice and his decision to let Rittenhouse choose the jury's alternates from the lottery. He even went as far as saying that he's thinking about not allowing cameras inside the courtroom the next time he has a big trial. What does it say to you about this judge who obviously is reading what's going on in media and what's being said about him, for him to address the court in terms of why he hasn't ruled on the mistrial, which, by the way, legal experts have said was odd that he didn't already make a ruling. Now, what he said in court was that he hadn't even read the motion that was filed on Monday and wanted to give the prosecution a chance to respond. Your thoughts?
I think that this judge consistently has demonstrated that he does not have the appropriate judicial temperament for this kind of trial. For a trial of this magnitude, where there are a lot of different motions, a lot of moving parts, he should be equipped to handle things, but his temperament has been consistently off. He has been very, very explosive, which I think is his way. He has demonstrated by his actions, by his conduct, by his body language, facial expression, bias more towards the defense. And that is certainly not what a judge should do in any case, especially not a case where someone is being accused of murdering 2 people and injuring a third person. So I think the fact that he wanted to address this in public probably demonstrates that he's under such criticism locally that he felt a need to say something. But the bottom line is his judicial temperament is not appropriate. He's made a lot of blunders, which I think would constitute appealable issues for primarily the defense. And so I do think that he should have ruled on that motion. When you ask for for a case to be dismissed for a mistrial with prejudice, meaning the prosecution would never be able to bring that case again, that's serious, that's severe. If he didn't read it because he thought it was so preposterous and ridiculous, that's one thing. He should have just dismissed it. But he didn't even read it, and to acknowledge he didn't read it, that is clearly a judge, I believe, and I have great respect for judges, but I believe this judge has not upheld the canon of ethics or done what he's supposed to be doing in this trial in a timely manner. And that is prejudicial, and that could be an appealable issue down the line.
And you're being watched. This is a televised trial. Do your job. Make sure that you're crossing your T's and dotting your I's. All right. The video evidence requested and seen by the jury had already been accepted into evidence, yet there were objections from the defense about one of the videos requested, the drone footage, which happens to be the clearest video of Rittenhouse shooting the first man, Joseph Rosenbaum. Why are they objecting to it now?
They're objecting to it now because the jury wants to see that footage. That is the single most important piece of evidence that the prosecution has introduced, and in closing went through with the jurors, scene by scene, and demonstrated, I think that's the strongest evidence, that this was not a case of self-defense. It shows when he dropped the fire extinguisher, when he shot him the first time, second, third, fourth time. It's the clearest evidence of that. So, of course, the defense is very upset. They probably wouldn't have cared if there were other footage that they wanted to see over and over and over again. But that's the strongest piece of visual evidence that the prosecutors introduced and used very effectively, particularly in closing. In their case in chief, I don't think they used it effectively. But in the closing, they nailed it. And this is a critical piece of evidence that goes directly to self-defense.
Mm-hmm. And this was the first time I actually agreed with the judge's ruling on this. But the defense, like you said, they didn't want the jury to watch this video more than once, which is crazy because you've got 12 people on this jury who may need it to be, played back a couple times. But when you're looking for, and this is what the judge said, when you're looking for the truth, when these are the fact finders, it is important that the court doesn't interfere with their quest to do so. So, of course, he allowed the jury to watch the video a number of times. But is that, again, telling for the defense that maybe this Joseph Rosenbaum victim may be problematic to their client?
I think it is telling. This is problematic. I think this video is problematic, and they should be worried about it because it's the most compelling evidence in favor of the prosecution.
All right, immediate past president of the National Bar Association and CEO of the CK Hoffler firm in Atlanta. CK, thank you again for coming on tonight.